Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about trademarks. Cases that should have gone to the Supreme Court of Canada, but didn't. Quality Program Services Incorporated owned a trademark for the phrase, "empower me." The Government of Ontario, in trying to encourage people to use more responsible energy resources in their homes, created a program that they called Empower Me. The difference is subtle, and it emphasized where the capitals were in the words empower me. And this was ultimately the subject of a complaint by Quality Services on the basis of the fact that the Ontario government had infringed the trademark. When the complaint was made, the Ontario government registered the Empower Me slogan as a mark of the province of Ontario, thereby bypassing trademark law. The government essentially gets the right to say, this is a mark of our government, and therefore doesn't have to be trademarked in order for us to protect our interest in it. Quality Program Services sued, alleging that this was a violation of trademark law, and the government couldn't just skirt trademark law by registering something as a mark if it was already used by somebody else and considered to be confusing. And the court agreed and awarded $10,000 in damages to Quality Program Services. Ultimately, the case went to the Court of Appeal, and the Ontario government lost there as well. They sought leave to appeal to the Supreme Court of Canada, and leave was dismissed. This case raises very important issues because we've seen numerous times throughout the Canadian governments and the provincial governments instances where existing logos or designs or trademarks are copied by government officials or by political parties in order to create something that is unique but isn't actually that unique. There's all sorts of examples of it on social media. So this tends to happen a lot, which means that the Supreme Court of Canada really should get invested in determining who gets priority, first to register or government. Because until then, government is going to continue to try and take away trademarks from the little guy. And this also raises concerns about a power imbalance. If you own a trademark and you don't have a lot of resources, the government can essentially litigate you into giving up something that you lawfully own and has lawfully been registered to you, because you don't have the resources to hire a lawyer to fight a lengthy trademark battle against an entity with unlimited resources. These types of power imbalances are why the Supreme Court of Canada is supposed to be there, to keep governments in check. And unfortunately, this case was a missed opportunity for the Supreme Court of Canada to correct what is effectively an unfairness in the way that governments can wield their power against individuals and corporations. Hopefully we get another case where the governments are put in their place and prevented from using logos and designs and trademarks and phrases and slogans that belong to individuals or small companies rather than taking them for themselves. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.